Well, thank you, everybody. As it was billed, it's sexually transmitted debt, and you need the document condom to help you out. So basically, we are a full-service commercial law firm, and when I'm talking about that, I'm talking about risk protection, essential document frameworks that you need to legally protect your business. We do estate planning for our business customers that includes corporate power of attorney, and we also do family law for our business clients. I mean, we do family law for other clients as well, but mostly we started our family law practice to help protect business owners. And so there's a range of things that we can do to assist you, even if you're already in a situation where you might be at risk from sexually transmitted debt. So what we are is we're a consulting group, but we have two entities under the consulting group. One is Digital Age Lawyers Proprietary Limited, and that's our commercial law firm. We have Aquarius Trading, which is Aquarius Lawyers. We do all things marine, blue economy, blue space, a lot of aquaculture and mariculture, and like we just picked up a commercial boat purchase where there's a dispute over our client did all the right things and got all the right checks and balances, and then when he started to do the repairs that were supposedly found, he has had to spend $65,000 fixing the boat because the surveyor didn't pick up all of the faults. We have an educational arm where we educate people about business issues. For example, over the next 3 months, we're doing a range of presentations to the Western Sydney Business Centre to help small business owners. One's the Business Owner's Guide to the Law. We're doing digital and social media law, and we're doing contracts and contractual issues for business owners. We have an entity called SMSF Lawyers where we look at self-managed super funds, and we also run audit programs for financial advisors because the regulations say that they have to be audited on a regular basis. And then Catherine has her own PR media arm. As I said to you, we've just been approached to get a whole pile of media articles out about topics that are of interest during COVID. So we very much approach our legal practice. We're probably not quite the same as other lawyers. We take a more consulting approach to it and a business consulting approach to it. When you come to us and we give you advice, we won't quote 55 different legal clauses or whatever. We hope that you expect that we know those things and we've researched them in relation to your matter, and what we'll give you is business advice based on that law. Our point of difference, I think, is our staff and the way that we approach our customers is very much partnership. We're not the, arrogant, lawyers that I often have ringing us up on the other side of matters. So in terms of sexually transmitted debt, how does it happen? Well, it happens because, I'll give you some examples. Tradies and their wives, family members being in business together, family members who may have separate businesses, but they're both directors on each other's companies. There's a variety of ways this presents itself, but marriage is the top risk factor. So if you have a business and prior to getting married, you should have what's called a binding financial agreement, which protects the business and makes sure that it isn't part of the matrimonial asset pool, if you like. And so nobody can be caught up in the debt practices. Because what you find in these types of situations is that purchases are made in the other person's name that they're not aware of, or they're made through joint accounts, or there's some secret spending by a partner. There's a lot of gambling that goes on with corporate assets. And then you get to the process where if people are separating, these assets become part of the matrimonial pool and don't stay with you, the person who's, sweated and slaved to set up the business. And as I said, gambling. So you can see on there the chart that credit cards are the greatest form of sexually transmitted debt, because you can just go out and apply for them in a business and keep getting more and more and maxing them out. Loans on corporate vehicles, student loans, borrowing from family and friends that the other person isn't aware of, medical bills. I had a client whose wife had gone and had a whole pile of cosmetic surgery and billed it to the company. Mortgages, properties are bought and the other party isn't aware of it. They just come along and say, oh, can you sign these documents? And somebody does, they don't read them. Payday loans for the very common in gambling situations, and home equity loans, because you can take out, equity on the home loan, and often it doesn't require both parties because it might be a redraw facility or something of that nature.
So Julie, just a quick question then on that
Yep.
table. It's not just business debt then, it's all sorts of personal debt as well.
Absolutely. Unless you have agreements, but most of what I'm talking about is debt that's incurred in a business that another party is unaware of, and then something happens and then suddenly they're caught up. I'll give you an example. I've been representing a woman who her husband was a builder, and he became bankrupt via a drinking problem. And so, of course, his building license got suspended when he became bankrupt, and he can't hold a new license for 3 years. So they bought a hubby franchise, and they put it in her name. And he continued to go out and quote jobs and do work that he should have only been doing as a builder, because if you're not a licensed builder, you can only build to 5K. She has a debt with one client where she has to redo the work and supply all the materials again of $75,000, and they're also in the middle of a separation. But this is her debt because she owns the business, and even though the ex-husband ran up the debt by not engaging in appropriate practices under the hire hubby rule, she's liable.
Yeah, okay.
So preventing an STD, get yourself some protection. It's really important to protect whatever assets that you have, including your employment income, which is what we were talking about before. And protection means don't open bank accounts, credit cards, co-sign loans. When you're moving in with someone, if you're on your second round of relationships and you're going to have a blended family, make sure that you sort out how, assets are going to be managed moving forward. I've just been dealing with a couple who both have children from their previous marriage, and they've just in the process of buying a house together and sorting out their estates and sorting out how, and we're doing a binding financial agreement for them where they, divvy up the pool and say how it's going to be distributed amongst their children and what each other gets from it. Because if you don't do this, your new partner will, after 12 months of being together, has a claim on any assets that you own. And, sometimes these aren't easy conversations to have, but you do need to talk about it with your partner, and you can talk about it retrospectively as well, where you work it out and you work out the best ways to protect the business and to protect your family and to protect each other. And they're conversations that you can have. And, like who owns what, who brought what into the relationship, what taxes are outstanding. Like, well, we've been working on a divorce settlement, and the husband parked nearly $1 million in the ATO as a credit, and we can't touch it because it's a business asset and it's not a personal asset. And that they had in place documents. But anyway, that's what he did. If you are in partnership with, your partner or a family member, or insist on transparency, that you regularly conduct some bank statement reviews, you make sure you're using a financial program like Xero, or the free ones are Money Smart, where you can see each other's information, but you cannot transfer funds. So you have view of at least of your joint financial responsibilities. Seek some professional advice. So before you join funds, move money around, apply for loans, set up a trust, be a guarantor, become a company director. All of these things come with responsibilities that you have to fulfill. And so you need to understand what it is you're signing on for when you set up a company and become a director. So the three key documents that we recommend to people are a binding financial agreement before the relationship begins to protect assets and the future, a loan agreement between the parties, which could be a loan agreement, but also a shareholder agreement, that there are variations for different circumstances, and an inheritance agreement. Who's going to get what if something happens to one of you? And this should assist you in preventing yourself being caught up in somebody else's behavioural patterns that incur debt in your business. And if you want to talk to us more about it, you can find us on these numbers, and I'm happy to take some questions.
Excellent, Julie. Very good. And it's good that I think your presentation aligns with your message about how you do things differently. It wasn't it wasn't too much detail, and it was nice and clear for us to absorb. Any questions, anyone? All crickets there, Julie.
All good.
And it is something we did speak about earlier. Yeah, one of the topics that we talked about in terms of risk management. That this is an area, and it is scary. And I suspect it's probably women probably get the raw end of the deal in a lot of these situations, where like your builder example, Julie, where this lady's been put into a debt situation without really understanding what she was doing and what the risks were.
Exactly.
When signing up with the business in the first place.
But the husband with the 100K cosmetic bills that he didn't know had been put into the company accounts.
Yeah, so it's on both sides then, isn't it?
Yeah, it is. It is.
Right, I'm just going to stop that recording.